welcome to Hot Issues. The story about the secret recording of judges in compromising positions continue to unfold. There are all kinds of allegations and responses to the allegations, and various procedures have been applied in the process. We are continuing our discussion on the saga within the judiciary. Welcome to Hot Issues. Hello and welcome back to Hot Issues. And as I said from the beginning, the story is continuing to unfold in the judiciary. The secret recording of 34 judges, the implications of that recording, whether or not indeed the judges behaved in an ethical manner and so on, all of that discussion is going on. And we are continuing our own conversation on the judiciary, the scandal or alleged scandal, and how we are dealing with that. And today, we are particularly privileged to have with us a very distinguished lawyer, a senior lawyer, who has, on occasions like this, been forthright in the expression of his views. Talking about Mr. Ayikoi Otoo, very, very senior lawyer, former Attorney General, and indeed, a member of the legal committee of the New Patriotic Party. Sir, you're welcome to the studio.
Thank you for having me.
Sir, were you in any way surprised by these allegations of malfeasance in the judiciary?
Well, thank you. These are rather embarrassing times. Rumors and allegations of bribery and corruption, I believe, have gone on over the years. And the issue has always been, where is the evidence? Is it because somebody has lost a case and therefore feels that the judge was or might have been influenced one way or the other? That is why he's saying that he didn't like the judgment which was passed or something. There are times you read some judgments and they look rather surprising to you, having looked at the evidence and the submissions made, and you ask yourself, how could the judge have come to such a conclusion? So strange things have happened over the years, and therefore this rather disturbing, video is something that, if you like, provides the evidence. That is, if everything on what we see is really true, there has not been any editing, there has not been any tampering of the audio or the visual or whatever, then it's rather worrying and a very embarrassing situation for the judicial service.
So in your many years of practice, have you come across cases such as those that are revealed on the tape?
Well, you see, the point is, if you look at the provisions dealing with, discipline of judges and, for that matter, magistrates, these are things that should happen in camera. Mm-hmm. So you are not expected, or we don't expect that these things come out in the open. I can tell you that they are magistrates and judges who had served on the bench and had been asked to resign, due to some of these allegations. Where the evidence is forthcoming, you are called and told that, look, my brother, ABC is not good enough. So advise yourself. And he offers to resign. So with my many years of practice, I can assure you that I'm aware that these things do happen and the people live quietly. Because the Constitution itself says that some of these things ought to be done in camera. So they are done in camera. You see, we are looking at the judiciary and the confidence in the judiciary. That if you don't handle it well, you will make one swallow to make a summer, or allow one swallow to make a summer. And therefore, one should be careful. If people should lose the general confidence in the judiciary, then where else do you go? So when one or two people are found in rather compromising positions, such as we found it, then you call them, they go through the disciplinary committee. Even yesterday, I was doing one for a magistrate, not this kind of situation, but another, circumstance altogether, that they wanted to find out whether it's a prima facie case or whatever he is alleged to have done, which might lead to his now being properly charged, and then consequences may follow. So they do occur, but not on this scale and not with visuals and audio, But people have been removed before. Now, if you go back to history, you'll find that Kwame Nkrumah removed some justices, including a chief justice, for having given a judgment which he didn't like. There's Otoo, Tayo Adamafio, and the rest. So some judges who sat on the case were removed. Now, if you recall, also during the time of Jerry Rawlings, a whole lot of judges and magistrates were removed from the bench. I think Atudazi would be the best, but he was then the chief of staff, I believe, to give us the background. But they categorized them into bribery and corruption and drunkenness, incompetence, and they were all removed. The worst part was getting 3 High Court judges really abducted and killed, That is removing them also from the bench, And like the Chief Justice, reminded the public that some of these things are ongoing. I have appeared for 2 Circuit Court judges who were all removed, what they call the Appointments and Disciplinary Committee of Judicial Council, So it's been ongoing. This is nothing, but because the emphasis is on doing it in camera, you wouldn't know. All you know is that this guy happened to be a judge. Now he has resigned and he's practicing law. It's only when you go and find out what led to his leaving the bench that perhaps somebody will whisper and let you know that, well, he was involved in some kind of difficulty. I'm not saying that it cuts across that anybody who has, because I know of a few who resign on very good grounds of health. Some who say their eyesight is so bad that they can't read the small prints. So it's better they leave. Some who just out of ill health generally, we can't sit for very long periods, especially Court of Appeal, Supreme Court, who also leave. Some who believe that sitting there up to 70 years, Court of Appeal and Supreme Court, and retiring, how do you enjoy your benefits? So why don't you leave early and then you can enjoy some benefits before going? So some retire on very good grounds. Others are asked to just, leave because we don't want to blow this thing, out for people to know what has actually happened.
So you more than all of us know that there's a principle in law which emphasizes the equality of citizens before the law.
Mm-hmm.
How do we couple that with the practice of hearing, criminal allegations against judges in camera?
Well,
how do we couple that with just allowing judges to resign and go home when others are convicted?
It's because of the greater good, sacrificing one man for the good of the entire society, and secondly because of constitutional injunctions, because if the Constitution provides that certain things should be held in camera, then it will be wrong for anybody to, take it out there. For example, if you read Article 1468 of the Constitution, it provides that all proceedings under this article shall be held in camera, and the justice or chairman against whom the petition is made is entitled to be heard in his defense by himself or by a lawyer or other expert of his choice. Mm-hmm. So the same law says we are all equal, and the same law says, well, when it comes to removal of judges, that ought to be done. And I'm saying that if you look at the greater good that will come out of it, if you have a case, you believe that somebody, is misbehaving towards you, is trying to be smart, is taking your property, and you think that this is the only place you can go and get justice. And at the back of your mind, you have this kind of evidence that, look, the thing is on sale, justice is on sale, so even if you get there, nothing will come out of it. Then what do? Are you now going to resort to, self-help? Look, this man, as the guy will say, take you to Jujuba and make sure that you don't come back to come and disturb him because he hasn't got the confidence in the courts, or he tries to maybe take cudgels and guns and whatever to do his own thing, takes the law into his own hands. And we believe that will not lead to a peaceful resolution of conflicts, But these are things which have been tried and tested. We used to have our own arbitral, committees for hearing cases and trying to resolve matters until we got this judicial system from the colonial masters, and it's been tried and tested in other countries. So why not? I mean, if you keep it well, you nurture it, it should be able to serve our purposes. And you find that the Judicial Council, has some duties to perform. Article 154 of the Constitution provides as follows: the functions of the Judicial Council are A, to propose for the consideration of government judicial reforms, to improve the level of administration of justice and efficiency in the judiciary; B, to be a forum for consideration and discussion of matters relating to the discharge of functions of the judiciary, and thereby assist the Chief Justice in the performance of his functions with a view to ensuring efficiency and effective realization of justice; and C, to perform any other functions conferred on it by or under this Constitution or any other law not inconsistent with this Constitution. So if you have a Judicial Council that has the mandate to do some of the things stated here, including, proposals for consideration of government for judicial reforms, then when you're having difficulties with the system, it only makes sense that you fall back on some of them, find out from the council what reforms do they have which may curb this kind of situation. There are so many scenarios that one could think of, and a few reforms that were initiated. You do recall that after the judges were murdered, abducted and murdered, we stopped wearing the wig and gown. After some time, we brought back the wig and gown. Then not long ago, we decided that it was no longer necessary to wear the wig, but you can wear your gown. So that is a reform. It's only when you are dealing with a criminal matter that you may dress fully with your wig and a gown on. Then we were not recording, we were doing longhand. So the judges had to sit there and record longhand for a very long time. A lot of people, lawyers started suffering from spondylosis because you have to stand while you are writing and things like that. Then we introduced a recording system, introduced the fast-track courts. That is a reform because we were then writing longhand. Then when it came, my main worry was electricity supply. Are we sure that we'll get constant and continuous supply of electricity? Said that this thing will go uninterrupted. Your guess could that be as good as mine, the difficulties we are going through. And then, unfortunately, we don't seem to have generator sets, plants, big ones, which could help to run the system. I hope that when we move to the new premises, maybe these things might have been installed. There were rooms that did not have air conditioning. They were generally dirty rooms because the wind blows and brings all kind of dust. You go there in your white shirt. Before you come, you picked a lot of dirt. Now we had, air conditioners, introduced. Then we had specialized courts, the commercial courts, land courts,
human rights courts.
Those are specialized courts which all also came on board as part of, Then we replaced the High Court rules, you know, a very old rule, 1954 rules were replaced with, I think, SAI 47, which is about 204, thereabouts, you know. And recently we've introduced something else, which is the witness statements. That instead of waiting to be surprised in the box for somebody to come and tell you stories which are not even contained in his pleadings and all that, file your witness statement ahead of time. We all know what the person is coming to say. He enters the box, we just go cross-examine him, and we save time. And then we moved on also. No, that came before this one, which is the computer selection of judges who will try cases. The belief that maybe some may influence the judges before whom cases went, so you could. But even, you know, the problems, there are judges, I think, on the tape or so, some people were saying, make sure that this thing comes to me or something like that. So they find ways of still doing that. And that was another, you know, attempt. The other area that we made is that delays, generally delays in the system. You know, you get one land case or chieftaincy matter, which may go on for years, you know. Is it the fault of the lawyers? Is it the fault of the judges? Sometimes you cannot blame either of them, because judges are human and lawyers are human. They may fall sick. Witnesses may fall sick. They are unable. They do other things. You know, Africa and our, you know, funerals. You know, somebody has a funeral and he has to travel and things like that. So sometimes you have these delays. And then transfers. You know, a judge may be sitting on a case and all you know, the next term is transferred. And some of these delays sometimes, you know, lead to people becoming anxious, you know, and you find, you hear stories like, oh, me, I went to tell the judge he should try and finish my case, you know, quickly for me. This thing has gone on for far too long. And there was this rather disturbing one, which has also changed with judicial precedent. The Supreme Court has now ruled that if you are hearing a case and for some reason, you know, the judge leaves, you don't need the consent of the lawyers and the parties now to adopt the proceedings. But it is now for the judge to decide, looking at the evidence so far, whether to adopt the proceedings and move on. That was a singular act which has changed a lot of things, because there's so many, you know, cases that have just stalled because the judges have either died, resigned, gone on retirement, been transferred, and then somebody tells you, I am not ready to adopt the proceedings. We have to start all over again. So can you imagine when you have done the case for 5 years and then you have to start all over again? These are things that sometimes lead them to. So these are some of the, you know, things that we may be looking at in terms of trying to introduce more reforms, you know, to take out the human element. To me, if you ask me, it is the integrity that should be number one in all these things, and being truthful to our judicial oaths. Because if you go and take the oath that you are going to be, you know, you're going to do justice to all manner of persons without fear or favor, you know, ill will or affection, and you start doing things which show that you have ill will towards somebody or you have affection towards someone, that you are not being truthful to your own oaths. And that, I believe, is a matter of your own integrity. And I don't know, how do you instill integrity? That is the issue. Is it by, you know, giving them code of conduct? Don't they have it? They have. We have the judicial oath of conduct. They know the things they should do and they should not do. So why do they still fall into this kind of, you know, trappings? And when the thing happens and somebody starts crying that he has been entrapped, you know. But knowing why should you allow somebody, for example, to walk into your house? It's not your relative.
With a goat. You
know, you don't know him. You know, why should you allow anybody to come to your chambers? Ask your clerk to say, this gentleman wants. And surprisingly, some of these clerks are rather they go betweens, you know. In terms of standing, I don't see how you should be so free with your clerk, you know, to the extent of some of the things that we are hearing. I mean, he should know his position, if he, or sometimes an usher. And most people don't know the role of these people because of the insistence that everybody wears a suit. You know, the person is an usher. His duty is merely to come and say, court ready, and then bang the door, 1, 2, 3, usher in the judge. In those days when they had huge chairs, you know, to pull the chair and allow the man to sit down, help him to sit down. Today with these swivel chairs, you don't even need these things. But of course, when there's noise in the room, somebody must alert the gallery that the judge is ready. So that is his job. And because he goes in to usher in the judge, somebody thinks that he has so much influence. He himself becomes an influence.
But the tape actually shows that they have a lot of influence.
But that's the point I'm making, that for the public, they think that these people have so much influence. And then the question I put earlier, how do you allow yourself, you know, to be influenced by somebody who is just coming to, you know, alert the public that, you know, and he wears a suit, and people think he's a big man. A clerk takes the case and calls the case, so you know that it's your turn, you know. Of course, you rely on them. There are judges who might not find some of the processes filed on the docket immediately. You call him, look, he says he's filed a defense. Can you look for that one quickly for me? It helps you and things like that. At the end of the day, you should just leave. You know, a registrar should help you with preparing the, you know, orders that you make. He will come and show the orders to you. If you approve of them, you sign. So the question I am asking is, how do you instill that integrity in the person? Say you should be of high moral or character and proving integrity.
So how do we do it? Hello, welcome back to Hot Issues, and we are in conversation with Mr. Ayikoi Otoo, a lawyer, and we are looking at the unfolding scandals in the judiciary and asking many questions as to whether we are doing things right or doing things wrong. Now, sir, the Constitution says that the trial of judges, when they are faced with such allegations, ought to be in camera. How come that we are showing the evidence in public? Is it not prejudicial? Are we doing things right?
It is not only prejudicial, but rather unconstitutional. Because when a constitution prescribes something, you must follow it. It's for good reason that this thing is prescribed. And especially even when people have gone to court asking that the thing be stopped, you know, it still goes on. And then you have others who say that, well, there's no injunction, and therefore it still can be aired, you know. The general principle in contempt is that you do not have to do anything which would prejudice the parties litigants before the court, you know, so as to, we tend to bring the court into disrespect or disrepute, or tend to interfere with the administration of justice, you know. So if somebody has gone to court and is challenging a process, and they say, well, don't show this, I'm going to show it, even against a constitutional injunction, it's problematic. Because you see, the Supreme Court had opportunity, if you remember the case of Bright Equity trying to remove Aqua from, you know, the office as Chief Justice, and then one Ajechum suing the Attorney General and the Bright Equity and taking it to court. You know, the fact that the matter was put in the public domain, you know, the contents of the petition or the press conferences were held and the rest. The Supreme Court ruled that it was in contravention of this particular article and clause, which says that it should be held in camera and ought not to be in public domain. Why in this particular case they allowed it, I don't understand. Again, you'll find that when it came to the suspension, you know, the two justices who are in court and one who is not well were left out. You know, so why? You now recognize that because they are in court, we should allow the court processes, and announce himself when another injunction was filed against the show in Kumasi, said that he now wants the processes to go on. You know, those are the things that as senior lawyers we keep advising the younger ones. You know, that you might not understand the reason behind a particular provision, and you think it's just a matter of practicing journalism and letting people say their say, and the freedom of the press and the rest. But there must be a good reason. By doing this, people's confidence in the judiciary may go down. And we are not talking about Ghana. I hear this thing is being shown in other places. Or some are saying they will show on Al Jazeera. And do you think the investor out there would want to come and invest in your country when you cannot, trust your judiciary? You know, and already we've had all kinds of difficulties with international arbitrations because they come and they don't trust your judicial system. They always say that, look, where there is some disagreement, we want to go out. Now you show these things, I will ask for Ghana, there is not safe at all. I beg you, never agree to go to their court. They will go and buy justice. So that will be the flip side that one should have to watch, whilst perhaps you think that you are fighting corruption, and sometimes the donors also put pressure. I can tell you as a former Attorney General and Minister of Justice, I know I worked with the Chief Justice as a National Secretary of the Ghana Bar Association and as a former President of Greater Accra Bar. We took the Chief Justice as our presiding judge in our region. So any problem we have in Accra, you don't talk to any other supervising High Court judge. You went straight to the Chief Justice. I've dealt with them, and I know sometimes the frustrations that they also, but the greater good, should guide us. That if at the end of the day, what we are going to do will lead to destroying, the judiciary. You think the policemen that they talk about, are not always having difficulties, the Attorney General's Department and the rest. Once you give people discretion, they do all sorts of things. But in order to keep the confidence of the public in the system, that is why you do these things on the quiet. That let's ease him out. We know he's going to collect bribe, but if you let people know, then others are asking the legitimate question, which I think they are entitled to ask. I lost the case before this judge.
Yeah.
Did he give me justice? Should the case be retried? Can you imagine the repercussion where the judge has been on the bench for years and people have lost cases, and sometimes in very bizarre circumstances are they going to ask that these cases be retried? But if these things are done on the quiet, they would not know, So whilst I would, not necessarily applaud it, say because of the effect that it would have overall on the judiciary, I would think that we should have rather, listened to the constitutional injunction, especially remind ourselves of the case of Ajay, because, John De Bugri has been talking about it. I refused to get into this thing when it broke. So many media houses called me because 3 of the High Court justices contacted me. 2 magistrates I helped to even, prepare their responses and all that. Because the letters to them said that they could come with lawyers of their own choices. And I wanted to assist, so I didn't want to talk. Some were luring me and saying that, but in the Bugri and the rest are talking, they are also defending. I said, no. Once you start a discussion, you don't know where to end.
Exactly.
Some of the questions that will be put to you, and if, like, knowing me, if I have to say it, I don't say why I should hide anything. I may end up saying something. But now that I'm no longer defending anybody, I'm free to discuss. And that's why I offered to come on this program. So
we're most grateful that you came. But sir, some of the lawyers have been raising another issue. I mean, this issue has been raised specifically by lawyer Ndebugri and Ifadate about the right of the accused person to identify his accuser. This is in reference to being hooded, in proceedings and so on.
Yeah.
What is your view on that?
I have heard that, again, you have to do some balancing act. This is somebody who has been doing some rather discreet investigations, and to show his face will mean that his job may almost come to an end, in the sense that if you know the person, I don't see how he can come and behave like Angel Gabriel. I tell you any stories, because immediately you see him, you can identify him and say, no, I have nothing to do with you. You are a nurse and I don't trust you. It's as simple as that. It means that a lot of the work that he might do, which will be of assistance to the general good of society, will be affected. It's true that you need to see your accuser. It's true that anytime you went to court and you want to cover anything, you are told to remove those things. But then do you balance that one with this somebody who can now be described as a whistleblower, trying to fight corruption, trying to get information? And yesterday it came up, somebody met me in court, and 2-3 lawyers were raising. I said, well, let them go to court then. Let them go to court for an order of mandamus directed against the committee that they should ask Anas to remove the hood and let the court rule on it. Because anything can be resolved by just going to court. So if they feel strongly about it, why don't they? It's a public body, they are doing a public duty. So they should compel them, if they like, that they want the man, and let the judge also do the balancing act and decide, because once you have a ruling on your side, you are covered. Whether the ruling is wrong or right, that is the ruling of the court until it is set aside. So I will urge those of them who feel very strongly about it that they should go to court, that they want the hood to be removed. So and then the ruling may bind them.
And sir, beyond the hood being removed, there are other things that have been said about the process of investigation. So, are you satisfied with the process? For example, it's being said that the initial investigations is done by a committee, whereas the Constitution prescribes a sole investigator.
Well, for the magistrates and judges, the magistrates and the circuit court judge, the lower bench, yes, that could be the position where you have maybe a high court judge. As I said yesterday, I was sitting on a high court judge sitting with 2 judicial service workers investigating, trying to find out whether there's a prima facie case at all. So you have to establish that one before you go to the next stage. For the superior bench, usually they go before what we call the Appointments and Disciplinary Committee of the Judicial Council. That is where their cases are heard, and you have a superior court bench, justice, presiding with other members. I think up to about 5 or so, 5 members who sit. The point of the matter is that sometimes when the thing affects us directly, we rather make a heavy weather of it. We are quick to advise others, but when it affects us, we don't seem to know the best way to go about it. The question of establishing a prima facie case is the whole issue. Let's look at the provisions. That is 146. Justice of the Superior Court, a chairman of a regional tribunal, shall not be removed from office except for stated misbehavior or incompetence or on ground of inability to perform the functions of his office arising from infirmity of body or mind. The latter part is very easy to prove.
Yes,
I mean, if you have
of mind and
body. If you have a stroke and it's clear that you can't write, and there was one judge who became, I don't know what they refer to as vegetable. He would just sit on the bench, say nothing, because he's the eldest or the oldest of the members there, most senior. He will be presiding, and yet others will be doing the work until, say, court rise, then we go. Such a person clearly has a problem of infirmity of body or mind, and it can be removed, But like one of the justices of Akufo was saying in the Ajay, is it sufficient to leave it so broadly to say that stated misbehavior or incompetence? What constitutes these things? What is stated misbehavior?
The ingredients.
Yes, and this where sometimes I regret having left the Attorney General's office early, because you find that, especially in UK and the rest, anytime they have an area which is not clear, they make sure that they bring an act. Just to clarify the area. That's it. Say you don't know what is stated misbehavior. These are the ingredients of stated misbehavior. Incompetence is when you cannot even deliver judgments, and the judgments you deliver or pay in quorum. They are not in consonance with modern trends and all that. You are incompetent. Procedures you don't seem to know and things like that. So you state them clearly. Anytime, like contempt, what constitutes contempt? Don't leave it out anymore. Bring a contempt act. Let's clearly state what constitutes contempt. Everybody knows. And then we move on. So that is number one. Then a justice of superior court, judicature or chairman may only be removed in accordance with the procedure specified in this article. In accordance with the procedure specified in this article. So there is no other place to go but to look at the procedures that are specified here. So one, President receives a petition for removal of a justice of the Supreme Court other than the Chief Justice for removal of a chairman of a regional tribunal. He shall refer the petition to the Chief Justice, who shall determine whether there is a prima facie case. What is a prima facie case?
I was going to ask that.
These are the issues, and that's why I was telling you that when it concerns us, that we start having difficulty. Now, how does the Chief Justice determine a prima facie case?
First of all, what's a prima facie case? What is it?
I mean, basically, all they are saying is that do we have the evidence, some kind of evidence that something wrong has taken place? Do you have that inkling at all? For example, somebody is alleged to have set up a private court doing his own thing within his court system. Where is the evidence? Do we have a record of proceedings which he keeps privately, where he records those private things in? Or we have a course list prepared by the registrar of the courts. He places before him and he goes along dealing with only those cases. Then prima facie, there is nothing wrong about what the man is doing. But if you go and you find a notebook, a record of proceedings in which he records his own cases, imposes fines and takes percentages, then you find something has gone wrong, and then now you charge him with some kind of offense and put him. So at first instance, minimum
threshold
of
evidence.
Do you have any evidence at all, whatever, to say that this person is doing something wrong? If you don't have it, then because remember,
prima facie evidence may not be sufficient to warrant prosecution or even administrative action in the final analysis.
No, this one says it must. Once you get the prima facie, then you move on to the next stage,
which is trial,
which is charging the person now, because you have something to show that he's done something wrong.
So, but would
you
it,
are not
would
to collect
it
money.
always be sufficient for conviction or for administrative action to be taken? The prima facie case is the minimum threshold.
Yes.
You need the maximum threshold to warrant conviction.
Yes. But once you have the evidence that something went wrong, you now move further to probe it I mean, you are not a persecutor, mind you. You are a prosecutor. So if at the end of the day you prosecute and a person gets through it because you are unable to prove beyond all reasonable doubt, so be it. You are not supposed to be a persecutor that by all means I want to get this person in. No. I have some evidence I'm working with. 60 to 40, I can secure conviction. So I go. And my 60 becomes 40. And his 40 becomes 60. He wins.
Yeah.
I mean, you should understand that you are not a persecutor, but you are a prosecutor. So I think it's okay for that purpose. But you see, the Chief Justice decides that there is a prima facie case. He shall then set up a committee consisting of 3 justices of the Superior Court or chairman of the regional tribunal appointed by the Judicial Council, 2 other persons who are not members of a council of state nor members of parliament or lawyers, and who shall be appointed by Chief Justice on the advice of the council. And then the committee, which is now set up, shall investigate the complaint and make its recommendations to the Chief Justice, who shall then forward it. So the prima facie first. So what we are doing now is what she calls the prima facie. You know, go in there, meet some people, constitute a committee. I am determining whether there is a prima facie case. I alone cannot do everything. So I've set up this small committee to help me to do it. Once I get the information, then I can move on to even the clause 10, that you could be, suspended. In the case of a justice of a superior court or a chairman of a regional tribunal acting in accordance with the advice of the Judicial Council, suspend that justice or that chairman of a regional, where the petition has been referred to a committee under this article. The petition has already been referred. Then you could be suspended by the president. So what is happening now is a prima facie stage. They have still not gotten to the committee of 3. That is my understanding. There are 3 justices of the Supreme Court and 2 others
who will determine.
Hello
and welcome back to Hot Issues, and we are in conversation with Mr. Ayikoi Otoo, former Attorney General and a very distinguished lawyer, and we are talking about the unfolding saga in the judiciary, the allegations, the claims, and so on, with specific regards to the Anas Arimuyao Anas recordings. Now, sir, I'm sure you followed the media reporting of all of this. Is it fair?
Well, let me put it this way. There are no absolute freedoms anywhere. And sometimes we take these freedoms too far. Sometimes I say that some of our media guys are still young, and they've not seen some of the experiences that others have gone through. And you wonder, somebody's parents, having found himself in this kind of situation, and the way, this thing will be blown on the air, and you ask yourself, how would the children and other relatives, feel, But because some of them are very young, they have youthful exuberance, and they are fighting, But you see, some of us used to be that belligerent. Somewhere along the line, you see that you'll be contending. I'm lucky I've gone out of it. But you'll be contending with, for example, BP, and then you'll be advised that, my friend, if you don't slow down, you go this way, you end up getting stroke, and that is life for you. Experiences of life should tone you down on a few things. But we take things and we don't think of the effects it's even going to have on the individuals concerned. And that's sort of worry for those of us who find ourselves up there, because anything could happen to anybody. But the way the press will handle it, as if, you should just drink some poison and get away, So we should be mindful of the concerns of others, and be a little bit circumspect, Having said the thing, put it out there that the things really happen, they are all true. Then you find later on some people now using the word allegedly. Allegedly, having said that, allegedly, So why did you at the start behave as if
everything
all
was true?
look at the judge whose name got mixed up. And at the end of the day, he was not even one of them.
What are the remedies available to this judge who
what
was
will he do?
wrongfully identified?
There's nothing he should do. He should just forget about it and let's move on. I mean, is he going to sue the judicial
But
service?
are there remedies?
Oh, I mean, if a reputation, of course, had been dented one way or the other, but it's been corrected at the end of the day, which is what is important, So I don't think that he should worry his head about that. It's a wrong, mistaken identity. It's been corrected, and we move on. But I'm saying that just think for a second that this is the person who has been wrongly identified, and you are saying all sorts of things on a morning show, sometimes afternoon shows, afternoon 12 o'clock, 1. And somebody's father is on the carpet,
And he hasn't done anything wrong.
He hasn't done anything wrong. That is why I keep on saying, let us be circumspect in the way we handle some of them, It's not like, we'll all grow one day, They can't say, okay, Obada, Obanina, Jelo money. You one day grow to come and see some of the difficulties that some went through. Nobody is saying that corruption and bribery should be, countenance one bit, but how do we, deal with it? I was listening to, Mensa Otabil saying that until you are tempted, you see, you always think that you can withstand certain things, but let them tempt you really. When you are really tempted, with money, with anything, women, like you saw, and then you see the metal of which you are made of. Before the temptation, but you just assume that it's okay. I mean, as for me, this thing I will never do. And at your age, I'm sure we'll be around the same age. You can go back into history, ask yourself the things you said you will never do.
Yeah.
And then when you grew, you started doing those things. And then you ask yourself, but how did I fall into this? And I tell people this. You see that sometimes you begin to worship your parents. You want to go to the tomb. You want to celebrate them. And it now begins to dawn on you that, but my father used to say this, I never listened to him. I now understand why. Oh no, I think I have to go and say some prayers at this. So please, that is my advice. Let us be circumspect in the way we do things. Let us realize that they are people's parents. They may be, you'll be surprised.
But there have been also incidents of downright misreporting. I mean, for example, in the course of the week, I saw headlines which said Chief Justice sacked 7 judges.
Yeah. When the people have been suspended.
And when the Chief Justice has not sacked anybody, she has no power to sack.
It's not done any such thing. Then you see on the front page, they are selling their newspapers. You are an editor, and you know what it means to sell your newspaper. That's those who have not listened to the news and they see it in print. Hey, people have been sacked.
Some judges sacked.
And it's not the best. I don't know.
So it's been suggested also that we should begin to look at the methods for recruitment of judges.
Yeah.
What is your view, sir?
It's ongoing already. It's ongoing. I mean, those of us who have been in touch know that earlier it was just a matter of applying, for the lower bench. You are interviewed and then taken. Then for the superior bench recommendation, you have to be recommended. It's not a question of application. But now it's a matter of writing exams. They write exams. And if at the end of the day, those who mark the papers think that you are not qualified to be a judge, you will lose out. So you can see a vast difference between the days where you merely applied and you went through an interview. And in those days, some people even turned down the appointment because they didn't like where they were being posted to. Today, no, you're going to write an exam. Promotions are also the same. You have to bring some of your judgment, civil and criminal, for a committee to look at it to see whether you qualify. All judges are first lawyers. So it's from the training that you've got to go back and see the nature of the training. We have difficulties sometimes with leakage of examination papers. It's not only
even at the law school.
Oh, wow. It happens, you know. So when you have things like that happening, it's not the best, you know. I mean, how can you be sure that this gentleman or this lady you are going to put on the bench really worked hard to get to wherever,
the law.
You know, he got to, you know, because of some leakages of, you know, examination papers, indulging examination malpractices. We've got to work on it. I have been a member of the Board of Legal Education before. I've been a member of General Legal Council, been a member of Judicial Council. In fact, when it comes to law or the judiciary, I think I've passed through quite a lot of these things. So I know some of this. So we have to go back, make sure that, you know, we know. And then there's another worrying thing happening. Is now that the Chief Justice said it the other time, is it at the bar conference, where law faculties are just roaming everywhere. Law faculties. Meanwhile, there's only one law school.
Two-story buildings in corners and so on. Yeah.
There's only one law school, and some of the people are taking a little to Kumasi, a little to Legon. The rest, the bulk, are here. So where are you going to put these people? So you know, introduce some kind of competition which unleashing things that we cannot hold. You know, are we ready to expand the law school or allow other faculties to go on to do it? Because if we are now reducing the 2-year training to 1, then it shouldn't be a big problem. All you need is one more room or something. After the law faculty goes on to do is, you know, and I'm be sure that you know who you are calling to the bar, because it is these same people who become judges.
So thank you very much for coming. We're most grateful that you came to help us to understand all these complex issues and so on. Well, this has been Hot Issues, and as we always say, the best is on this station.